Good morning, everyone. Hello and welcome to our last session of our summer series of Virtual Elder Law Day. My name is Christy McKenzie. I am Assistant Coordinator of Neighborhood Services here in the Department of Senior Services with Erie County. I would like to take a minute to thank those who have made this summer series possible again this year. Our County Executive, Mark Polencars, Karen Nicholson, the CEO for the Center for Elder Law and Justice, and our Senior Services Commissioner, Angela Marinucci. A few things to mention. This presentation will be recorded and the PowerPoint will also be available on our website where you registered at erie.gov/ELD. I will put that in the chat as well. We ask you if you have any questions that you do enter them in the chat and refrain from entering any personal information. We will be answering all questions at the end of the presentation today. Please allow me to introduce our guest speaker, Judy Wagner. Judy is an attorney practicing in the areas of estate planning and trust, and she assists clients with Medicaid planning, long-term care planning, and wealth preservation. Welcome, Judy. I'll turn it over to you.
Thank you, Christy. It's so great to be here, and thank you all for joining us today on this beautiful sunny morning. Looks like it's going to be a beautiful day out there today. So thank you for taking a few minutes to tune in with us today. As Christy said, I am an attorney with Harris Beach, and I've been with Harris Beach for about 16 or 17 years. But my area of practice has always been elder law and estates and trusts. So this type of law is all I do. My firm Harris Beach is really wonderful. We have offices across New York State, but I have attorneys at my disposal who just practice in real estate, just practice in corporate law, so that it allows me to just concentrate in this type of law. So, as I go through the presentation today, I usually wrap up with, make sure that you find an experienced elder law attorney, because this is a very specialized area of practice. And it's easy to make mistakes if you don't practice in this area and really know what you're doing. So, and you'll see as we go through how much detail there is here. But elder law and estates and trusts have been my passion since day one. When I was 15, I went to work in a nursing home, and it all evolved from there. So I love what I do, and thank you all for being here. So let's dive right in. We have lots of material to cover. There we go. Okay. So I did my welcome already. This is kind of summary of what we are going to be covering today. We're going to look at all of the options to pay for long-term care. We're going to look specifically at Medicaid eligibility, the rules for transfers of assets, some asset protection techniques, crisis planning, and I'll explain what that is a little bit later. And you'll see throughout the program how important planning is. So my job as your elder law attorney is to anticipate the worst. Of course, we all hope that the worst doesn't happen, that you can live a long life, maybe not ever need to go into a nursing home or need a care facility. But my job is to take a look at what would happen if that were the case, and what can we do to help so that in the event of a catastrophic illness, that your assets are not all depleted to pay for that care. So paying for care is the first thing that we evaluate. An assessment of your financial situation early, it really helps ease the stress later on. I always tell my clients it's not ever too early to plan. So, as I'm getting older, my husband and I are getting older. We have this plan in our head, and we've been saving with that plan in mind. So these are types of things that you evaluate early. Informal care options. So if you need care, a couple of different things that you want to take into consideration. What are your care options? Who do you have on your team? Do you have children that live nearby? Are your children out of town? Do you have good friends? Do you have neighbors available? Who makes up your team? Maybe it's your church family, um, uh, or your friends. There's all kinds of different options, but evaluating who your team is and what kind of roles that they play is a very important part of this analysis. So evaluating your own personal resources. What are in your savings and investments? Do you have IRAs? Do you have 401ks? Do you have long-term care insurance? All of these different things are a part of the analysis of how might I pay for care someday. Medicare, just quickly, Medicare is an entitlement that all seniors have at the age of 65, but Medicare does not pay for nursing home care. It pays for some rehabilitation services and some inpatient care, of course, but a lot of people think that Medicare will pay for nursing home care or long-term care, and it does not. And that plays a big part in our analysis. Medicaid is a poverty program. So Medicaid is always what we call the payer of last resort, and they are the ones that are going to pay last. Once you have qualified with their income and their resource levels, gone through the steps to qualify for Medicaid, Medicaid does pay for long-term care. Every nursing home accepts Medicaid for the payment of long-term care. Assisted living facilities and memory care facilities, some accept Medicaid and some do not. So if you're in a situation where you are thinking that either you or your loved one is going to need placement, an analysis of the level of care that you need is important. And then what facilities supply that level of care and whether or not they accept Medicaid, whether or not if a lot of memory care facilities are exclusively private pay. They do not accept any kind of Medicaid. But other assisted living facilities on a lower level of care do. Veterans benefits are important if either you or your spouse has at least 1 day of service during wartime. There are benefits for home care as well as institutional care, and sometimes these benefits can be the difference between your loved one being able to stay in a certain assisted living facility, even if they don't have a ton of assets. If they have a decent amount of income plus the veterans benefits on top of that, a lot of times that is everything that is needed to pay for a really good assisted living facility. If there is a high level of service related disability, at least 70% service-connected disability, then potentially you would be maybe eligible for 100% of skilled care to be paid for. Those are types of things that definitely are worth exploring, and to make sure that you're in the veterans system so that if this time comes that you can transition smoothly into these kinds of benefits. So let's jump right into Medicaid eligibility requirements. So remember, this is our worst case scenario, but I like people to understand how the rules work so that if this happens to you, if this happens to your loved one, you understand how the eligibility process works so that you don't get tripped up. You aren't making mistakes. People are just living their lives, being generous with their families and having fun with their money, having fun with their life. This usually is the last thing that people are thinking about. But the system has forced us to be able to need to pay attention to this. So I'm going to go through the eligibility requirements so that at least you have a basic understanding of how this works. For an individual, Medicaid allows you to have $16,800 in resources, and $50 a month in income. So this is a single individual with no spouse. 16,800 they let you keep. $50 a month from your income, your Social Security, your pension, any investment distributions, income, that sort of thing. That's where the income comes in. As far as the resource rules are concerned, for if there is a spouse, the spouse is allowed to have what we usually call the well spouse. If the spouse is living at home, they are the well spouse. They can have between $74,820 and $137,400 in resources, and $3,435 a month in income. I'm going to talk a little bit. The next slide, I'm going to talk about what the resources entails. But as far as the income is concerned, the income limits for spouses apply to both spouses' income. So if, for example, if the wife is the well spouse at home and the husband is in the nursing home, in a lot of cases, the husband's income is higher. He was the one that went to work, so he's got higher Social Security. He maybe has a pension, and the wife stayed home with the kids. Her Social Security is lower. So if that's the scenario, then even though the wife doesn't have her own income, she can take from her husband to bring her up to that $3,435 number so that she is not impoverished. You're allowed that amount of income. If the income exceeds that, then it all depends on who's in the nursing home and who belongs to the income. So in my example I just gave you, husband's in the nursing home, wife is at home. If their income exceeds $3,435 and the $50 that the husband can keep, then 100% of what the excess is goes to the nursing home towards the cost of care. If the situation is swapped and the wife has a lot of income and the husband doesn't have much, then everything that's over the 34-35, the wife is only required to contribute 25% of the excess towards the cost of her husband's care, and she can keep 75% of her income if it's hers. So those rules are kind of tricky. That's what I'm here for, to help work you through those types of issues. The range in the resource limits depends on how much money you start with at the date that the person goes into the nursing home. So for example, if you go into if the husband goes into the nursing home with $264,000 in assets, so twice the 137, then when they spend down to the 130 to that limit, they can keep 137,000. So it all depends on what you start with and then what gets spent down until you apply for Medicaid. The principal residence, the primary residence, is always exempt. And one automobile is always exempt of any value. We're going to talk a little bit more in the program about the residence and planning for the residence. So I'm going to jump past that right now, but we'll come back to that later. So what counts? This is what I mentioned, that we're going to talk about, that resource limit, the 74,820. What counts towards that number? And the answer is just about everything. Medicaid doesn't leave any stone unturned. All accounts, regardless of how they're titled. Joint accounts is always a question that I get asked. Hey, Judy, my daughter has been joint on my bank account for 10 years. That means only half of it counts, right? And the answer is no. If there are any type of banking accounts, checking, savings, CDs, that money markets, those sorts of accounts, if they are joint with another individual, then the Medicaid presumes that account to 100% belong to the applicant. The only exception to that rule is if you can actually prove that that money does not belong to the applicant. And I've had it happen. I have kids that have always lived with their parents, and they combine their income into one bank account, a joint account between mom and daughter or mom and son. And under those circumstances, we can go back and we can prove that part of that account belongs to that child. Their income was going into the account. they were paying all the bills from there, we can prove that. But if we can't, if really it's just mom's account and daughter was on as a convenience, it belongs 100% to her. That rule is different for any type of investment account, brokerage accounts, stock accounts, mutual funds, joint real property. Under those circumstances, because of the investment accounts, those are governed by securities regulations, they are treated differently. If the child has been on those accounts for 5 years or longer, then it's considered to be 50-50. So it just depends. And this is how another thing that I help work people through. For married couples, all assets belonging to either spouse are available regardless of how they're titled. I have a lot of clients that are in, second marriage situations, blended families, or they'll come to me and they'll say, look, we've been married for 50 years, but she has always kept her account separate. The husband has always kept the account separate. The wife has always kept the account separate. They in their own minds, they view them as separate. Medicaid views married couples as one economic unit. So it doesn't make any difference how they are titled. Medicaid is going to look at all of the assets for both spouses with a married couple. Bank and investment accounts, stocks, bonds, we talked about, those can be, those absolutely count. Savings bonds that are in the drawer, cash value of life insurance with a face value of greater than 1,500. And this always trips people up because I ask people, I send out my nice long questionnaire to get all the financial information, and I ask people about their life insurance policies. And there's a Prudential, there's a couple Prudential policies, in the hutch. And when they pull them out, they unfurl that, the old days where you had the policies in the plastic container, and it all of a sudden there's 5 of them and there's $75,000 in cash value. People don't realize that this counts as an asset, because if you cash those policies out, you'd be able to use that $75,000 for the cost of your care. And Medicaid doesn't care that the death benefit might be $200,000. If you've got cash value of $75,000, then then they want it, and they expect you to use it towards the cost of your care. Life insurance policies are always something that I carefully review when we're talking about financial resources, because we can very easily protect those policies, and by protecting the cash value, we are protecting the death benefit. We have a lot of places in our area that your pension, if it's a New York State pension or a General Motors pension, and when the husband retired, he took the maximum single life pension option, and bought a life insurance policy to supplement that. In the event that the husband died, the wife would have this life insurance policy to take care of her for the rest of her life. That was their retirement plan. That's something that we need to be very careful to protect, because in that scenario, all of that income goes away. And if you also lose the life insurance, that might put the spouse in a very precarious financial situation. So that's something that we want to take a close look at. Real property other than the primary residence, which is treated as exempt for a married couple, then that the hunting camp that is joint with 4 other family members, or the place that's at the lake, or just this week I had a situation where the family had their primary residence, but they also had an investment property where the daughter lived, and they didn't understand that just because that daughter lived in that property, they are in a tough spot, because that second house counts as an asset, and the husband is in the nursing home. So that's going to be a problem. This is something that we have to plan for early, so that you don't get in this troublesome spot. As far as the house is concerned, the house is exempt as long as the well spouse is living there, as long as you have a married couple. If you have a single individual, then the house, they still can't make you sell it, but they can put a lien on it in that situation if there is no living spouse that's using that house for their primary residence. So I always tell people, even though you have that exemption while both spouses are living, we have to plan for the possibility that someday there may be just one of you. And then if that situation happens, then you're not going to be able to protect that property. So planning early with real property is so very important. What doesn't count? Next, what doesn't count? Principal, the biggie here is principal balance of retirement accounts. A lot of people don't know this. I've had hospital discharge planners, I've had nursing home people try and tell families that they have to spend their IRAs down, and as a part of the Medicaid qualification process, but that is not the case. Anything that is a pre-tax retirement account, IRAs, 401ks, 403bs, deferred comp, any qualified investment is exempt from Medicaid as long as it is in pay status. What pay status means is that if you have an IRA and you're taking your required minimum distribution from that IRA, you are as long as you are taking that distribution in a monthly pattern, then Medicaid exempts the principal balance of the account. So if your IRA minimum distribution is $12,000 a year, as long as you are taking $1,000 a month from that IRA, Medicaid can't touch the principal balance of the account. A lot of times that's good news for people. And when I said my husband and I are planning for our long-term care planning, part of that is having our savings go into IRAs and 401ks because we know that those accounts are inherently exempt, and without having to scramble or without having to put assets into a trust or anything like that. It just is, it's something that is exempt right off the bat. One thing I like to mention when we're at this point in the program is that for any of these types of accounts, the family can be the beneficiaries. So you could literally have a $500,000 IRA, have the parent be in we have a person in the nursing home, we're paying the pay status contributions. When that person passes away, that money in that account goes to the children. The only time that there is an exception to that rule is if that IRA account is invested in an annuity. So a lot of times people will say, or people will have their IRA, they'll retire, and they will go to their investment representative, and the investment representative will put it into a prudential or an equitable annuity. Under those circumstances, if that is the case, when you go in to apply for Medicaid, Medicaid is going to require that the county be named as the primary. If there is no spouse, the county is going to be named as the primary beneficiary and not the children. So that's something that we can cure at the last minute just by switching out the investment, just by taking it out of the annuity and putting it into mutual funds or putting it into a CD. It's a simple fix. You just have to do it before you go in and apply for Medicaid. So that's just, if you have annuities in your investment portfolios, it's just something that should be on your radar, that you need to ask more questions if a Medicaid application is necessary. Prepaid funeral arrangements are always exempt for whatever you need. If you want the Taj Mahal of funerals, then you're able to have that. But when you go in and do a Medicaid application, funeral arrangements have to be made irrevocable. So you don't want to ever set up any more than you actually will need, because you're not going to get any of that money back. It still is an option to be able to prepay funeral arrangements, obviously for your spouse as well, but also prepaid funeral arrangements for children and their spouses. And again, these all have to be made irrevocable. We used to use this type of planning technique a lot more in the past, because the arrangements didn't have to be revocable. You could take once the person in the nursing home passed away, you could go back to the funeral home and take your money back. But you can't do that anymore. So if you're going to use that prepaid funeral arrangement technique to spend down some excess resources to get to the Medicaid limits, you just have to be aware that these arrangements are going to have to be irrevocable. Those kids and their spouses will always have to use that money for their funeral arrangements. Life insurance with a face value of $1,500 or less, regardless of the cash value. So this can be done either with one policy with a $1,500 face value, or if you have three $500 face values, and you've got a $5,000 cash value, those policies are exempt and you do not need to cash them in. The look back period for asset transfers. Whenever I'm doing an Medicaid application for a client, we have to provide 60 months of financial records. Like I said, they're not going to leave any stone unturned. They are going to do detailed financial scrutiny of all accounts. They're going to ask to see your tax returns. The list of things that you need to provide with a Medicaid application is very long. Every single bank statement, every single investment statement, your tax returns for 60 months, every annuity statement, every trust agreement, everything. What they are doing is they are going through all of these financial statements and they're looking for transfers. They're looking for money that you gave away, because they are going to presume that if you gave money away, that you did it to qualify for Medicaid quicker. We used to have some flexibility in these rules, because the actual rule is that any transfers made in order to qualify for Medicaid quicker are assessed a penalty. But if you made a transfer and your motivation was not to qualify for Medicaid quicker, then those are supposed to not be penalized. But the reality of the situation is that when you go into Erie County Department of Social Services and you do a Medicaid application, they are going to ding every transfer. If you can't prove where that money went, it's going to be considered to be an uncompensated transfer. They're going to look at any transaction that is $2,000 or more, and if you can't prove where that money went, it's going to be a transfer. I had a case once where the client liked to have was an old Italian guy. He was awesome. But he liked to have a wad of cash in his wallet. He was an old school guy. He would go to the bank and take out increments, cash withdrawals of $2,000 frequently. And he said to me, Judy, Medicaid is not going to tell me that I can't have a wad of cash in my wallet and be able to go have a steak dinner every night of the week if I want to. And I said, I understand your frustration, but yes, they can. And this was a big problem. We could not prove where the money went. The withdrawals were frequent, and it was a problem. So these types of things, as you age, have to be on your radar with the way that you're handling your financial situation, because it could potentially be a problem. The uncompensated transfers are made by they're going to look for the applicant and the spouse. So this leads us to the penalty period. So if you have uncompensated transfers, there are withdrawals from the bank account that we can't explain. Now what? Calculation of the penalty period. How this works is that the total value of all of those transfers that we can't identify are divided by what the state calls the average monthly cost of nursing home care in New York State. The reality is that this isn't really accurate. They every couple of years they do they reevaluate this and say that they do the average, but the reality is that this isn't really, it's not an actual number. But as you age, you have to really be careful about the transactions that you do because of the possibility of this being dinged as a penalty. So how it works is that these are the 2022 rates for each region in New York. You can see that the Western New York region, the penalty rate is $11,884. And what this means is that Medicaid, if you have made a gift or have an uncompensated transfer of $11,884, then that equals 1 month of care that Medicaid will not pay for. So in the example there, if 4.5 years ago, if you gave a $50,000 gift to one of your children so that they could use it as a down payment on a house, that's a 4.21 month penalty period where Medicaid will not pay the nursing home. The penalty period begins to run on the first day of the month following the uncompensated transfer, provided that the applicant is otherwise eligible, and so they're eligible on the income and the resource side, and is in a nursing home and receiving skilled care. So otherwise eligible and in a nursing home before the penalty period starts to tick. How this works, the problem with this is that mom is in the hospital. She just had a stroke. And 4 years ago, she made that $50,000 gift. What's going to happen is that the discharge planner is going to ask you to fill out that financial form. So they're going to ask for all of the details of mom's financials. And then the very last question on that form is going to be, have you made any transfers in the last 60 months? Have you given away any money in the last 60 months? And if the answer is yes, then the nursing homes are going to be very leery about accepting that person because they are afraid that that person is going to have trouble qualifying for Medicaid and they are not going to get paid. The law really is not on the nursing home's side, so I don't blame them one bit for being cautious about this because once they accept someone, they have a legal obligation to take care of that person, which means that they can't discharge them if they don't have the ability to pay. And so if you've got a situation where you've got a 4-month penalty, the nursing home accepts you, and that 4-month penalty comes up during the process of the Medicaid application, then and that just means that the nursing home is not going to get paid because if the applicant has spent down to their $16,800 in order to be eligible for Medicaid, now they don't have any money left. They are doing the Medicaid application, and then all of a sudden there is a 4-month penalty. There's no money to pay them, so the nursing home is on the hook. This is what the nursing home is afraid of. So planning so that this doesn't happen is very important. It's my goal to make sure that I work with the nursing homes a lot. They bust their behinds to take care of our loved ones in kind of a thankless job. It's a difficult job. It's a difficult field to be in. Taking care of our elderly folks in nursing homes. I don't want them to ever not get paid. So part of our planning is to make sure that they are always going to have a payer source. There are some exceptions to the transfer penalty rules that you should know about. You should know that when you have 2 spouses, any amounts of resources can be transferred between spouses without penalty. So if the resource limits are the 74,820 or the 137,000, typically what we have to do is transfer all of the assets to the well spouse, because remember the spouse in the nursing home can only have 16,800. So we have to move those assets to the well spouse in order for the spouse in the nursing home to be eligible for Medicaid. But those transfers between spouses are okay. That's not a problem. While the transfers are exempt between the spouses, the opposite of that rule is that a transfer by one spouse to a third person will affect the nursing home eligibility of the other. Because remember, I mentioned before, spouses are one economic unit. This becomes an issue with blended families, and one spouse is taking care of his kids, the wife is taking care of her children, and they think that they think that the actions of one are not going to affect the other, but that's not the case at all. It will. I've had a lot of folks come to me and ask about getting married, spouses that are unmarried, and I have a younger client right now that has Parkinson's. She's younger than me, and she has advanced Parkinson's. It's terrible disease. But she had been with her significant other for years and years. And we had the same presentation, and they came to me afterwards and said, should we get married? And I'll tell you, I hate being in a position to tell people whether they should get married or not and have it be for financial reasons. So I first qualify any advice with the fact that you do what you want and we will make it work. If you want to get married, you get married. We will make the finances work. But in this particular situation with this couple, her partner was still working, and he had a lot of IRAs from his employment, and in their case, it would have put his wealth on the hook for Medicaid if they got married. So, putting their relationship aside, my advice was for them not to get married, to remain single, and then only her assets were on the hook if she needs care someday. So those are real issues that you have to that you have to take a look at. I'm trying not to watch the chat, but I just saw the question come up. What about spousal refusal? And spousal refusal is an option in New York State. However, Erie and Niagara counties are both very aggressive when it comes to spousal refusal. They will sue every single, at least in the past, they have sued every single spousal refusal that we have submitted. So what the spousal refusal is one spouse saying, so we shift all of the assets to the well spouse, and then that well spouse says, I'm refusing to contribute to the cost of my spouse's care. And then what's supposed to happen is that those assets are not considered to be available by the spouse that's in the nursing home because of that spousal refusal, and then they would qualify. But the state and the county have the ability, because a spouse has a legal obligation to support each other. They have a legal obligation to support one another. The county can sue them for support, and saying, okay, now the state and the county are going to be financially responsible for this person. So we're going to take the initiative to sue that spouse for contribution towards the cost of their care. And usually what happens is that we end up negotiating with them, and we come to some sort of an agreement. I have not done spousal refusals up before COVID. I hadn't done them in a long time, because an elderly spouse that's in that position typically is not in any position to be defending a lawsuit by the county. It's very, they already have so much emotion going on. It's very difficult for people. I've had younger folks do it because they were more, they were more able to handle that type of thing. So if I had a younger client with MS that we did a spousal refusal, and then we negotiated with the county and came up with an agreement on what the spouse would contribute. But if you live in Monroe County, we have a Rochester office that is very active elder law practice in Monroe County. They do spousal refusals all the time, and Monroe County only sues the very most agreed, the highest amount of refusals. If the spouse has a ton of money, Monroe County is going to sue them. So, but they do it downstate all the time, and it's kind of unfair that they can do spousal refusals downstate, and not have, just because they don't have the resources to sue people, they don't do it. Other exempt transfers, a couple other planning opportunities. If you have a disabled child, or a trust for the benefit of a disabled child, you can make unlimited transfers to that disabled child, or to a trust that's exclusively for that disabled child without there being a penalty. This becomes problematic sometimes because if you've got 3 children and you're transferring assets to only 1 child, that could be an issue. If that child is disabled and they are getting benefits, government benefits that are resource based, like SSI and Medicaid, then those transfers may affect that child's benefits. So these things are kind of tricky, that we have to deal with, but this is an option. And I always ask if there are any disabled children, because there might be a planning opportunity there for asset protection for us. As a part of the spend down, we call it, purchases for fair market value. If you have more assets than Medicaid will allow, and you spend that money on yourself, on the spouses, then that is okay. Any money that you spend on yourself is perfectly fine. So if you have a house and you're making improvements to an exempt home, that's a good place to put money. House repairs, new appliances. If you've been putting off that car upgrade, now's the time to buy that car because the car is exempt. Any types of these things, but you have to keep an eye on the calendar with these types of things, because Medicaid is going to snapshot the assets on the date that that coverage is needed. So if you are looking for coverage on September 1st, you need to make sure all these purchases are done and paid for, and the money is out of the account by September 1st. Otherwise, it's not going to work. So that's something that I help people work through. Prepaid burial expenses, we already talked about. That is any money that you have in a prepaid burial account is those things are exempt. So let's talk about asset protection and irrevocable trusts. This is the situation where you might not have, if you don't have the 5 years, if you did no planning, or if you did some transfers 4 years ago and you didn't make it through the 5-year penalty period, this is the type of thing that we should that we're talking about planning with. So first of all, just as an introduction, I want to make people aware that the types of trusts that are not useful for Medicaid planning, that don't work for Medicaid planning, any revocable trust, because the grantor has complete control over those trusts, are not useful for Medicaid planning. They are available to creditors, including Medicaid. Revocable trusts have a lot of really important uses, and in most cases it's to avoid probate, but they are not useful for Medicaid planning. And a lot of people will come in and bring their binder in to me that they went to Salvatore's 20 years ago and got a stake and paid $5,000 and came out with this binder with this trust in it. First of all, if the trust is funded or not is, did they even fund the trust? But even if they did, they think that this is a trust that's going to protect their assets from Medicaid, and it's not, because they have complete access to it. Any type of an irrevocable trust with any type of a discretion to distribute principal, then the entire trust is available as a resource. So if there's an irrevocable trust with the discretion for the trustee to distribute principal, then that trust is not going to work either. So it's important to evaluate these types of things. If you have an existing trust, bring it in. Let's take a look at it. Let's make sure you know what you have. so you don't get put in a bad position at some point. Irrevocable Medicaid asset protection trusts we use a lot for long-term care planning. They work very well for asset protection. The irrevocable trust cannot provide the grantor access to the principal, but can permit access to income. So technically speaking, what you're doing is giving up the right to the, when you're looking at a 30,000-foot view, the grantor is giving up the right to the principal of any asset that they title to the trust. Funding the irrevocable trust will start the clock running. So this funding is crucial. Just by creating the trust, by doing the document, by getting it signed, that does not start the clock running. The asset has to actually be transferred into the trust. So that means doing a new deed, transferring the title from John and Jane Jones into John and Jane Jones's irrevocable trust. Opening a brokerage account in the name of the trust and transferring assets into that trust brokerage account. Transferring the ownership of that life insurance policy from you as an individual to the trust. Those types of actions start that 5-year clock running. Properly drafted and funded irrevocable trust can protect assets after the expiration of the 5-year penalty period. This type of a trust is designed as what we call a grantor trust, and what that means is that the IRS treats that trust as an asset of the grantors. So usually the first question that I ask, or the first question that I get when we're talking about this with folks, is that am I going to lose if I put my house in this trust, am I going to lose my tax exemptions? And the answer to that question is no, you are not, because the IRS considers you to be the rightful owner of this property. So your STAR exemption, your veterans exemptions, whatever you have, those are going to follow that property into the trust, and you continue to get those assets or those exemptions rather. The assets in the trust also still get what we call a step up in tax basis. So as an individual, if you bought the house for $20,000 and put in capital improvements and your tax basis in the property is $50,000, and now with the crazy real estate market that we have, that property is worth $250,000. If that property is sold during the grantor's lifetime, you continue to be able to use your capital gains tax exemption. So there's no capital gains tax liability due. But what it also means is that if you pass away with the property in the trust, your heirs now are not going to have a tax liability because they are entitled to what we call a step up in tax basis. So what that means is now their tax basis is the value of the property on the date of the grantor's death. And if the property is sold shortly thereafter, they pay no capital gains tax. So this type of trust definitely has favorable treatment as far as the IRS is concerned. So just a quick example. Whoops, that didn't come through very well. Oh, here we go. Oh, look at that! How fun that is. So you're creating a trust. You're creating an irrevocable trust. The grantor transfers assets, a home and a home to the trust, into the trust. That transfer is subject to the 5-year look-back period. So by doing this, it doesn't escape the 5-year look-back. It just means that it's getting the clock started as soon as this trust is funded. All right, so you have to name a trustee. You can't be your own trustee. Usually it's one of the children or a close family member. I actually didn't realize this was going to happen, so this is kind of fun. The grantor is entitled to the income from the trust, so you can. Right now, I actually have a client that I actually did planning for years ago, who moved $500,000 in National Grid stock into an irrevocable trust, and she's been living off of the income for all these years. Her and her husband lived off the income until he passed away. but she takes the income from the National Grid stock, but the stock stays in that trust. And as I just explained, because that National Grid stock, that client got it by because he worked for National Grid, so it has a very low tax basis. We're leaving that stock in the trust now until the wife passes away, and now then the children will get a step up in tax basis, and their basis will be the value of the stock on the date that the mom dies. So it works out very well. You can't have access to principal. Um, uh, the grantor has given up the right to the principal, and they cannot directly withdraw the principal from the trust. But however, when we design these types of trusts, we try and do as much as we can to give control to the grantor. So there is a provision in the trust that says that the trustee can make distributions to the beneficiaries in their discretion, and that way the beneficiaries, if you need to get some of the money out of the trust, you can distribute it to a beneficiary, and then the beneficiary can do whatever they want with that money. So this is kind of a backdoor way of us getting money to the grantor if it's needed. My mom has one of these trusts, and if she needed a memory care facility that is not eligible for Medicaid, then I could make a distribution to myself and then pay for her memory care. And so that's kind of the way that we get around these types of things. Principal distributions to a class of beneficiaries is what I just explained. Capital gains tax exemption is preserved if the house is sold. We talked about that already. After the grantor's death, the money from the trust is distributed to the children, to the beneficiaries, subject to a limited power of appointment. And what the limited power of appointment means, that's one of those control things that we build in for the grantor, so that they have the ability to change their mind who the remainder goes to. So in this particular example, it's going 50-50 to 2 children. But let's just say that the grantor decides that they would rather have the money go to their grandchildren and not their children. The grantor can make an amendment to the trust, change the distribution to the beneficiaries using this limited power of appointment. And this gives the grantor some muscle, because they have the ability to change their mind throughout. Life changes, relationships change. You never know what's going to happen. So this limited power of appointment, giving the grantor the right to change where the remainder goes for their whole life, is an important control measure. They also have the ability to change their mind who the trustee is. So you might pick one trustee, and maybe down the line you don't want that person as your trustee anymore. The grantor has the ability to change their mind who that trustee is, without the consent of anyone. You also, one of the other big questions that I get is, can I revoke this? Can I get rid of this whole thing if I need to? And my answer to that is yes, because I don't do any type of planning that I can't undo, because life changes and you never know what is going to happen. And so I want to always make sure that things can be undone. For this particular example, with the consent of the trustee and the beneficiaries, an irrevocable trust can be revoked. So if you've got a child that's not in agreement with that and you want to revoke the trust for some reason, the grantor can remove that child as a beneficiary and put someone else on, or just remove them altogether, and then you don't need their consent. So it gives you a lot of muscle with the situation. So crisis planning quickly. What if you don't have 5 years? What if something unexpected happens? Everything is fine, and then one day mom has a stroke, and there's no way for her to be cared for at home. Then what? Crisis planning using a gift and loan technique is something that we can consider. So this is a situation where child calls me and says, my mom just had a stroke. She didn't do any planning, but she always wanted to. She's got $100,000 house. and $100,000 in resources. How the Medicaid qualified loan works, or the promissory note plan works, is that you would gift half of that $200,000 to the children. So in this example, maybe we take the house and we transfer it to the children. Then the remaining $100,000 is loaned to a child or children with the agreement, with a simple promissory note that says, I promise to pay my mom back X number of dollars, $12,000 a month for the next 8 months. And what that does is it takes that $100,000 when you loan it, it removes it from mom's assets. So now when she goes in and does the Medicaid application, she has under the $16,800, and she's otherwise eligible, but now she's got a stream of income because we made a gift of $100,000. Medicaid is not going to pay the nursing home for 8 months. And so we need a stream of income available to pay the nursing home for that 8 months. So you're going to take that loan payment and the parent's other income and use that to pay the nursing home. So this is just like if you loaned me $100,000, I'm going to pay it back to you in once a month, $12,000 a month. I'm going to write you a check. You're going to accept the check. You're going to put it into your bank account and you're going to pay your bills with it. This is the same concept. The child is repaying a loan that the parent made to them. Mom is putting the money back into her checking account. And because we've structured the loan to be close to what is needed to pay the nursing home for 8 months, then we've got that payment structure so that the nursing home always gets paid. At the end of the 8.5 months penalty, then Medicaid kicks in, and we've protected about half of those assets. With this type of a plan, we always have to do the Medicaid application. We get financially eligible, but then we do the Medicaid application first in order to get that penalty clock started. So there's a whole lot of moving parts that go along with this type of planning, and but it works. This crisis planning any type of crisis planning technique has to be implemented prior to all of the assets being spent down, so the cash is available for the loan. So we use this a lot often when clients come to me and say, mom made a gift 4 years ago, and we know that we're going to have a penalty, but there still is money available. As long as we have that cash available for the loan, then this type of plan works. It's a corrective measure when we have unexpected situations come up, but it is an option for us. Be informed. Work together with your team, with your elder law attorney, someone who focuses their practice on elder law. It's easy to make mistakes if this is not what you do, and I can respect the fact that you've had your attorney that maybe did your simple will or did your real estate transactions. They've been your family attorney for a long time, but if they don't do this type of work, they may not be experienced in this type of thing. So having someone that's experienced with this type of practice is crucial. The earlier you begin the planning, the better. Obviously you've seen from how the rules work. If you can plan prior to the 5 years, we can do a much better job of planning, but it's never too late to plan. And always, even if someone comes to me and they've been in a nursing home for a year and they still have assets, we can do the gift and loan plan and protect some of the assets. But as we wrap up here, I always want people to know that the elders are always my clients. They are my main priority. Placement of, if they need care, is my main priority. I always want to make sure that they get all the care that they need. Although we've talked a lot about asset protection today, this is secondary to making sure that the parents get the care that they need. And if we can't make it work and protect assets, then it is what it is. But the parents are always my clients. Even if it's the kids coming to see me, the parents are always my clients. And when we're assessing financials, we never put all money into a trust. We always make sure that we have plenty of money outside of a trust to be able to pay for any type of care needs that person needs, because they are who is important to me. But I also respect the fact that that people want to leave a legacy to their family, and if we can do that, then that's a bonus. Okay. Christine, I see lots of questions coming in. Do you want to jump in and start giving me the questions?
Sure, yeah. Okay, let's see what we have. We have quite a few, which is good. What about if a daughter provides bank statements showing her paychecks direct deposited and takes that money out to make an account solely the mom's? Will that still count all as the mom's?
If the daughter's income, if the income is combined into one account, and so the income is combined into one account, and the daughter is carving out her half and withdrawing it, then 100% of that what's left is going to count as the applicant's resource. So yes.
Okay. And do annuities count?
Yes, annuities count. Annuities, it depends on whether they are an IRA annuity or a non-IRA annuity. So we talked about this a little bit. If you have an annuity that is that an IRA that's invested in an annuity, then you've got that issue with the beneficiary designation being the county, but they do count. And there are options for having annuities be considered to be, if you're taking a stream of income from that annuity, but it's almost better not to plan with it that way, because it almost never works out to your benefit if you take that option and have Medicaid consider it to be a stream of income, because the county is going to get it all in the end. So, I mean, but that is an option.
Okay. Is there a limit on the value of a car?
Funny story with this. No, the answer to it is no. I have a client that has a very rare Corvette that's worth, it's like the color, it's got the split back window. His wife has MS, and we specifically asked this question because we wanted to be sure that there wasn't going to be an issue with him being able to protect this car that is very valuable. And the answer that we got was no. You can pick the most expensive car, and that one is exempt. I also have had clients. I had a client that didn't even drive, that bought bought a very expensive Mercedes to spend down, and it was an exempt asset. After the Medicaid was approved, she didn't even drive. She gave it to her granddaughter after Medicaid was approved for her husband.
Okay. What provisions cause the trust to be a grantor trust from income tax purposes and also allows basis step up FPR errors?
The grantor, there's a section in the Internal Revenue Code, 675, I think it is, in the Internal Revenue Code. Don't blame me for being a nerd that I know in IRS codes. But if you have one of those, there are several different things that cause a trust to be considered to be a grantor trust, and one of them is being able to substitute property of equivalent value. That's the one that we hang our hats on, and that is specifically noted in our trust that you can substitute property of equivalent value. That makes it be categorized in the grantor trust area. What was the second part of the question?
I think it said for errors.
Oh, for errors. Okay.
Yeah, for income tax purposes and allows basis step up for errors.
Step up. Yep. So as long as you have those, those things, and the basis step up is also, as long as it would be includable in that person's taxable estate, you're eligible for the basis step up.
Okay. What if a home is sold? What happens to the money? Does it go back into the trust? What if they buy another home?
Yes, so if the house is sold during the grantor's lifetime, the money stays in the trust. The proceeds check is going to be made payable to the trust. Trustee is going to go get open a bank account with the name of the name of the trust. So it stays under the umbrella of the trust and stays protected. You want it to stay under the umbrella of the trust, but you can either leave it in cash and investments, those proceeds, or if the grantor is going to buy another house, the trustee, remember, is kind of the quarterback with all of this type of thing. So the trustee is going to be the one that is going to sell the current house and then buy the next one. But the next one is also going to be titled under the name of the trust. So it just really is logistics as far as the purchase and sale is concerned. The only downside to it that people should know is that you can't use properties that are in an irrevocable trust as collateral for a loan. So you always have to be dealing with cash. You can't get another home. I always tell people, if you want to have a home equity loan, go get it before we put the property into a trust. Or if you have an existing mortgage, there's no problem with us doing that. You're just not going to be able to get another mortgage. And I got this phone call a million times when interest rates were so low. Judy, they won't let me refinance my mortgage because the house is in a trust. And I said, I know, I told you that. So
Okay. For a trust, do they have to put all their assets in there?
no, absolutely not. And we never do. Because like I said at the end of the program, I only want you to put assets in the trust that you think you're not going to need. So if you've got $1 million in an investment account, or if you've got $100,000 in an investment account and you want half of it to be protected for your heirs and you need the other half for your care, that's what you want to put in. But remember, you're giving up the right to the principal of any assets that you put into the trust. So it's going to be hard to, you're going to have to jump through hoops to get them back if you need them. So I only want you to put in assets that you don't think you're going to need.
There's a couple more questions. So keep going. Does the loan receivable count as an asset of the applicant?
No, it does not. When you structure the loan, you are creating an income stream. So the only thing that is counting is the income, not the value of the loan receivable. It's just the income that's coming in from the loan. So that's what makes you ineligible for Medicaid for a period of time when you have that stream of income. If you've got a $12,000 a month payment coming in from a loan, you're going to exceed the income limits. So you're going to get what they call limited coverage for a short period of time. And then as soon as the loan payments stop, then full coverage for Medicaid kicks in and Medicaid pays the bills.
Okay. And then there's another, why not just use your mom's money to pay the monthly nursing home cost until she has spent down to the resource limit rather than a loan?
Because there would be, if you did that, which you certainly can do that, then there would be no asset protection. So if you use mom's money to pay the nursing home until it's gone, then you've spent down the money, you've used the money for her care, but you haven't protected any of it. So it's only when you have the opportunity to protect some of that money that you would use the loan.
Okay. A few more questions if you have time for them. I have time to ask.
I do.
Can a car title be signed over to a child up to the date of death?
If you don't, well, yes, you can. But if the car is, if the car is exempt for, if you've got a Medicaid situation that you're dealing with, you can't sign the car over to the child prior to the Medicaid application. Otherwise, it's going to be a transfer of assets that they will penalize. So you have to wait until after the Medicaid is approved. But if you are not dealing with Medicaid and this is just a general question about transferring the car over, you can do it right up to the date of death. Yes.
Okay. Is there a limit on the frequency that you can buy new cars?
No, but you can only have one.
Okay.
So,
I thought I remember saying that.
yeah.
If a pension is cashed out into an IRA annuity, is that exempt from listing the county as a beneficiary if you can prove it was from a pension?
No. If it's in an IRA annuity, then it has to be have if you're doing a Medicaid application, the county has to be named as the beneficiary.
Okay. And what if the payment from deferred comp is annual, not monthly?
If there's absolutely no way because of the plan provisions to make it a monthly, you would have to prove that to Medicaid, first of all, that the plan does not allow a monthly distribution, but only an annual one. They will allocate it. They will prorate it over 12 months and count it as monthly. But I mean, it still could come out annually, but you would have to have a letter from the plan or something like that that says that the plan does not allow for a monthly distribution, only annual.
Okay, we have one more. I'm not sure if she's asking, how often do you work with elder law attorneys about guardianships? If that's for yourself or for her?
I work, well, I do guardianships. I try really hard to make it work without a guardianship because it's a very complex procedure. And it's a Supreme Court. If you're dealing with a disabled adult and not someone who's developmentally disabled, it's a petition to Supreme Court. That's just one of the, and I know hopefully everybody was on with Linda Greer for the first program when she talked about estate planning documents, and I'm sure she told you how important it is to get those estate planning documents done so that you don't have to go down the guardianship road. But I do it. I'm selective about what guardianships I take, just because I'm really busy, and some of them are very time intensive. So.
Okay, we have a lot of thank yous. Great presentation. Last question, and then we'll wrap up. Can crisis planning include buying an expensive car as a means to reduce assets?
Yes, you can. That's something that you can, that's something that you could do at the last minute, subject to the timing that I talked about, as long as it's done prior to the the date when Medicaid coverage is needed, then that definitely works. And I've had people do it.
Okay, well, thank you, Judy. You provided so much comprehensive information. Thank you for answering all the questions. Lots of feedback. Thank you. Great presentation. For everyone still on, we will be providing the slides as well as a recorded presentation on our website probably by next week. And again, thank you, Judy, for taking the time. Thank you, everyone, for joining our series this summer. This is our last presentation, and hopefully enjoy the rest of your summer.
And hopefully we'll be in person next year for
Yes.
Elder Law Day. So please come and join us in person, hopefully next year.
Yes, thank you, everyone.
Thanks, guys.